Hey, everybody. Today's legal question is what should be expected from the probate process when there are minors involved? This has a few nuances, and so I'd like you to stay tuned. Before we get there, I'd like you to imagine a friend going through what if scenario that creeps into their lives, but they were totally prepared because you shared this video. We'll appreciate it, as will your friend. I'm Valerie Zammitti, an estate planning attorney in New York and New Jersey, and we're here to help educate everyone for free. So please drop your questions so hopefully together we can help some folks before something happens in their life. Now, it is certainly a tougher situation and harder to imagine the passing of a younger individual and the impact it can have on a young family. Unfortunately, it does happen, and we hear about it more and more. Perhaps that's just a sign of me getting older, but it is becoming more apparent to me that it happens more frequently than we imagine. And when a person passes earlier than expected, it is more likely that they didn't have an estate plan. Firms such as ours hopefully are trying to educate folks in that younger state of life in helping them and their younger families get their planning done sooner. However, without a plan, this will result in certainly court involvement, where these minor individuals of the decedent will be or could be very likely be determined as a beneficiary of that person's estate, parent, or what have you. And within the court, they're going to want to designate an outside party, usually a local attorney, to act as the guardian of the property for those minor children to represent those interests. Now, I know that might seem strange because there could be another parent who's still there, represent, with the child and is their guardian as far as them as a person. But here, the interest of that surviving spouse, we'll call them, and the kids are, separate. And they're kind of not, I don't want to call them in conflict, but they're separate interests. And so the court needs to assign a neutral party to represent the kids. Now, that, of course, can delay the process a little bit. These guardians have to kind of review things in a more thorough fashion, prepare a report for the court, etc. Now, any assets that are in this decedent's estate held in a bank or financial institution that will be distributed to a minor child, they typically have to hold on. It's typically held by that institution until such time as the minor reaches the age of 18. And then they get distributed at 18. And that could be so scary if these recently minted young adults are receiving significant assets. It could be a little danger to themselves and maybe the outside world. They'll set them free with a lot of money. Maybe not, but in many cases, 18 is pretty young if there are, funds of some size that will be coming to them. As a last comment and note, this can be true not just of bank accounts or other financial accounts, but can be true even of the family home. If the home was not owned with joint right of survivorship between the spouses, which can happen, and I did a recent video on that as well, then a portion of the home may be owned by these minor children once they reach the age of 18. We hope this information was helpful and that you've learned something new today and that you choose to share. As always from us, please take care.